Hi, this is Barry Hamo. Thanks for stopping by for another dose of bite-sized bits of knowledge where we give you meaningful information in a short amount of time. Today we're jumping into probate, and let's talk about why you need to know about probate now so you don't wait till it's too late. Probate is a process. It's a court process that starts after you pass away. If you pass away with assets in your name. Yes, you can open up a probate if you don't have assets in your name, and there's reasons to do that. But typically, the driver of probate is to move assets out of your name and into the hands of your beneficiaries, but going through what I like to call the toll booth of probate. Here's what it is. First, a personal representative has to be appointed. In other states like New York, where we have our other office, it's called an executor. People know that word better. So the personal representative has to be appointed by the court. Again, it's by your will or by your statute. This is a fiduciary role. You want this person to be trustworthy, responsible, and organized and hardworking, because it's a job. It really is. So you can choose who that person is, or the state will choose for you based on the statute. The person, the personal representative has the fiduciary obligation to move your estate through the process, starting with identifying the assets that are in the estate. Assets are everything you own. Tangible, intangible, business, cars, planes, trains, automobiles, bank accounts, savings accounts, annuities, life insurance. It all could go to the estate. And they have a job of figuring it out. Once they figure it out, they gotta disclose it to all the interested parties. Who are the interested parties? Beneficiaries and creditors. Beneficiaries are those people who you decide are your beneficiaries, or the state will decide for you if you don't decide. They will be chosen. It's just a matter of whether you want to decide. Beneficiaries have a right to notice that there's an administration, that there's a will, that there's no will, the assets and an inventory. The creditors also have to be notified too. They have a right to collect as well. So the third job of the personal representative is to identify creditors. Creditors have to be notified. If you don't know who they are, then you just publish in the paper, which is what you always do. And if you do know them, or they are, quote, reasonably ascertainable, then you have to give them actual notice. You have to send them by certified mail a notice that says you have a certain amount of time to make a claim against the estate, or else you lose that right. And their clock doesn't start ticking until you give them notice. So it's a very important thing to pay attention to as a personal representative. Timing matters. So the assets, beneficiaries, creditors, we affectionately call it the ABCs of probate. There's an inventory, there's dealing with the beneficiaries or purported beneficiaries. If someone challenges the will because they're not a beneficiary and they want to be one, you can expect conflict. Creditors have a right to be paid before beneficiaries get paid, so there could be conflict. If there's a business, which we'll talk about more later, the value of that business can be a creation of conflict because creditors and beneficiaries may disagree, and there might not be enough to go around. So that creates another conflict. Assets, beneficiaries, creditors, inventories, accountings, lots of potential opportunities for conflict. It's very unpredictable. It could be very cerebral though at times. From our perspective, it's an interesting area of the law. But it is an area that can cause a lot of financial burden, emotional burden, doesn't help families when they get into conflict, and most importantly, it is avoidable with some thoughtful planning in advance. We do a lot of that too. So, I hope you found this helpful, little crash course on probate. Thank you for stopping by, and stay tuned for more.